All right, welcome to the Data Practices Potpourri webinar with the Data Practices Office. Thank you for joining us. For those of you who are not familiar, the Data Practices Office is a small office in the Department of Administration. We're a statewide resource on data practices and the open meeting law. Most of what we do is respond to questions related to those laws from members of the public and government. We help the commissioner with issuing advisory opinions, and we also provide legislative assistance and training. This PowerPoint is posted on our website, so if you'd like to go back and take a look, it's on the page where you registered. We also record our webinar, so if you missed part of today's webinar, or you want to go back and watch it again, or find another one in one of our prior series, they're all posted on our YouTube page. I'm going to show you how to find those videos on our website, which is the link on our slide here. So this is our website. If you go to the bottom of our website, there is a YouTube icon there that you can click that will bring you to our YouTube page. Otherwise, you can go to our News and Events tab, click Events, Webinars, and then there's a link to our YouTube channel there as well. Here is where you can find all of the PowerPoints from each of our webinar series. So that's there for you. I'm going to click our YouTube channel link. And here's our homepage. You can click on videos to access all of our YouTube videos or playlists to watch different webinar series. In addition to the website, if you'd like to download a copy of today's PowerPoint, I'm going to share the file right now so you can download it and save it to your desktop. Okay, there should be a pop-up on your screen, and if you'd like to save the PowerPoint, you can go ahead and do so. I'll also share it later on in the webinar while we're taking questions, so you'll have an opportunity to download it as well. Today is our April Data Practices Potpourri webinar, which will be an opportunity to hear what issues that data requesters and government entities are encountering this month. As usual, we'll leave some time for a Q&A session at the end of the webinar, so feel free to send in your questions as you think of them using the Q&A panel on your screen. When sending in your questions, please send them to all panelists though, so we can be sure to see them. All right, so recently we're seeing larger and larger data requests for larger and larger data amounts. So for years of emails or property records dating back 10 to 15 years, these can lead to an incredibly large amount of responsive data. So we hear from entities asking how they should go about responding to these requests. So question number one, what do we do if a data request is too large to respond to? With public data requesters, government has a reasonable amount of time to respond to a request. What is considered reasonable will depend on many different factors, including the size of the data request, the amount of responsive data, whether redaction is necessary. Some strategies and best practices for responding to these large requests might include staying in contact with the requester to communicate that you've received their request, that you're working on it, and if necessary, clarifying any aspects of the request that are unclear. When possible, it's helpful to provide estimated timelines to the requester as well. There's no overly burdensome exception to responding to data requests, so entities must respond. However, some of the requests might take much longer to respond to. An option for managing some of these larger requests might be to provide data on a rolling basis or providing access to the requested data as it becomes available in batches. Just as a note though, for large requesters where the requester is the data subject, so the data is about themselves, they're requesting data about themselves, the response time is still 10 business days, as the data subject response time does not contemplate the size of the request. Due to this quicker response time for data subjects, it's beneficial for entities to have a process in place to confirm whether data subjects are asking for data on themselves so they can prioritize these requests. All right, question number 2. Who may access private data on minors? So the rules govern access to data on individuals. In the rules, there's guidance on who may access private and confidential data on individuals, and specifically private data on minors. We can start with the understanding that an individual is defined in Minnesota Statute 13.02, subdivision 8, and indicates that in the case of a minor, individual includes a parent or guardian, or an individual who's acting as a parent or guardian in the absence of a parent or guardian, except that the responsible authority must withhold data from parents or guardians upon the request of a minor if the responsible authority determines that withholding the data would be in the best interest of the minor. The rules go on to expand upon this access and indicate that the minor, including their parent or guardian, those within the government entities authorized and entities authorized by law, or entities or other individuals with express written consent can access private data on a minor. But there are many cases where it may be complicated to determine whether the parent or guardian has legal custody of the minor. The rules contain a presumption that a parent has authority to access private data on the minor unless the responsible authority has been provided with evidence that there's a law or court order, such as a custody order, that removes the parent's legal custody. Without legal custody, a parent cannot access private data on the minor. Further, the rules reiterate that minors can request that parents with legal custody be denied access to the private data. So specifically, the provision that outlines that requirement is Minnesota Rule 1205.0500 subpart 3A, and it states that responsible authorities must provide minors from whom they're collecting private or confidential data with a notification that the minor has the right to request that the parental access be denied. In doing so, the responsible authority can require the minor to submit a written request that the data be withheld with the reasons for denying parental access and have that be signed by the minor. It's important to emphasize here, though, that access depends on legal custody as opposed to physical custody of a child. Although there may be physical custody restrictions or arrangements, access to a minor's data is dependent upon legal custody. So on a related note, we also received a question about data guardian ad litems are entitled to access. So what data should a guardian ad litem receive? Public, private, confidential? Generally, a guardian ad litem is considered a member of the public for purposes of data practices. However, they may be entitled to access not public data depending on whether the court order that names the guardian ad litem indicates they may access not public data about a specific individual. If they have written informed consent from the data subject, they can access private data about them, or if there are any other court orders that permits them to access that not public data. All right, question number 4. Does a subpoena provide sufficient authority to access not public data? So if you work for a government entity and are served with a subpoena, you should always consult with legal counsel regarding your obligations to respond and how to respond. Generally, not public data may only be released to those with statutory authority, court order, or written informed consent. A subpoena does not have the same legal authority as a court order, but it's worth noting that if you receive a federal administrative subpoena or a federal grand jury subpoena, you might be required to release that not public data that's requested in the subpoena pursuant to the Supremacy Clause in the U.S. Constitution. So if you receive a subpoena for not public data, you should consult your attorney and they'll likely refer you to the Minnesota Rules of Civil Procedure or Criminal Procedure in filing an objection or a motion to quash based on the not public classification. At that point, a judge may issue a court order for the release of not public data. But public data, on the other hand, are available to anyone for any reason or no reason at all. So any public data that would be responsive to the subpoena could be released. Question number 5. Is there public data in attorney billing records? So in Advisory Opinion 05-009, the Commissioner discusses the City Pages versus State of Minnesota case and the court's analysis regarding 13.393, which is the Attorney Data section of the Data Practices Act and billing records. Generally, 13.393 indicates that attorney data are not government data, and so they do not need to be provided in response to a data request. However, not all data created or held by an attorney for a government entity are attorney data. In City Pages, the court found that the work product doctrine did not protect the attorney's billing records in their entirety. So there might be public data and billing records after the redaction of privilege or work product information. This also supports the idea that the public should be able to access data regarding how much government spending on services or paying its employees and contractors. Okay, question number 6. What is the classification of the cost for dues, fees for union members and fee payers? So in general, information about union dues or fees is likely presumptively public when not associated with a particular employee. However, whether an employee is a fee-paying member of a union is private personnel data under Minnesota statute, section 1343, because it's not called out as one of the specific public data items on government employees. If you watched our personnel data series, you'll know that personnel data, the public presumption is effectively reversed. And so all personnel data on employees are private unless specifically called out as public. So if the entity has union dues or fee data that are not specific to a particular employee, but rather general information on union costs, that's likely public. One last thing to note about union dues is that although which employees are paying members or not is private personnel data, unions may access certain private personnel data to the extent that that the responsible authority determines that the dissemination is necessary for conducting elections or notifying employees of their fair share fee assessments and in implementing certain provisions of chapters 179 and 179A. Also, the Commissioner of the Bureau of Mediation Services can order dissemination of certain personnel data to unions as well. Okay, so those were some of our top questions this month. I'm going to put the PowerPoint up again, and we're going to take some questions. I see that a few have already rolled in. If we don't get to your question during this Q&A session, we'll follow up with you. Also, if it's very fact specific, you can always feel free to email us or call us at the contact information on the slide. So I'll share that PowerPoint again, and then I'm also going to put a survey out there in the polling panel for you to complete while you submit your questions.
Okay, so we've got a few questions here, and so we'll start with one that whether a parent still has a right to receive educational data on his or her child, regardless of the custodial status, is that correct, unless the parental rights have been terminated? Right, and so when we're talking about the ability of a parent to access data about their minor child, and their custodial status, we're talking about the legal custodial status. And so if their parental rights have been terminated, then a parent would no longer be able to access data about their minor child. But if it's physical custody, where there may be an agreement where a child lives with a mother part-time and then a father part-time, that is a situation in which parental rights have not been terminated, and so the parents would still have access to data about their minor child, regardless of where the child is living, on a day-to-day basis. And again, taking a look at Minnesota rules 1205.0500, so it's 1205.0500. The rules say that responsible authorities are to presume that parent has the authority to exercise the rights of accessing data about their minor child unless there's been other information provided that state otherwise. And so just I recommend taking a look at that 1205.0500.
Okay, and we have another question that says, is private data on minors accessible to a parent or guardian who has custody of a minor when the parent or guardian is a suspect or has been arrested for a crime against their child or minor? So this is one of those situations where I think folks responding to data requests are kind of uncomfortable, understandably. But again, unless there is some sort of legal instrument that has removed those rights from a parent, they do have access to the data about their minor child. So even if they are suspected of a crime or involved in possibly some maltreatment allegations, unless there is a legal document saying that they cannot have access, they are allowed to have access.
We have a question that asks, I think they're talking about the personnel data question or the union question. Does this pertain to all data? Data is considered private unless specifically this is public. I thought it was the opposite of this. You're correct. So the Data Practices Act has a public presumption that all data are public unless classified as not public. However, the personnel data section in particular, so Minnesota statute section 13.43, subdivision 4 of that section states that personnel data on government employees is private unless specifically listed as public. And so it's only that section, that personnel data section, where most data on government employees are private unless specifically listed as public. And then subdivision 2 of 1343 has a long list of things that are always public about government employees.
Okay, so we have another question about clarifying if there's a large subject matter, I assume data subject request, does all data need to be provided within 10 days, or is it acceptable to provide some data within 10 days and then treat it like a rolling production? And so when it comes to large data requests and the requester is the data subject, you are obligated, under the Data Practices Act, to provide the data within 10 business days to the data subject. And there's no exception to that. And so this can certainly be a challenging situation, especially if there's a lot of data and a lot of information that needs to be provided as part of that data request. And so, from a practical perspective, certainly provide all of the data that you can within the 10 days. Once it's beyond that, you are technically in violation. You would technically be in violation of the Data Practices Act. And so this would certainly be an opportunity to, speak with the requester, clarify the request, work with them to explain the situation. But there is no exception when it comes to the 10 business days when the data subject is requesting the data. So you would be obligated to provide that within 10 business days, and certainly you should make every effort to do that.
All right, we have another question. We have a lot of great questions. Keep them coming. This, I believe, comes from a law enforcement agency. So the question is, are copies of citations public? This is going to be one of those situations where you're going to look at Section 1382 if you are in a law enforcement agency. Under Subdivision 2, it specifically says arrest data includes actions taken to cite, arrest, or incarcerate, etc. So with regard to citations, some of that data is likely going to be public. You want to look at subdivisions 2, 3, and 6, and anything that's in there can certainly be provided to the public. If there are rights to appeal, that citation, for instance, then technically it's still an active investigation and there might be some subdivision 7 active investigative data. If the person has just paid their citation and they've moved on, they've accepted responsibility, then generally the data is all just going to be public. So again, if it's an active citation and it hasn't been paid yet, or their appeals rights still available, you're going to want to look at 1382 subdivisions 2, 3, and 6 for the data within that citation that are public.
We have another question that says, we recently had an employee that requested salaries of all directors. We know this is public info, but trying to determine if this is a data request. So you're correct. What government employees make is public. And so that would be public data on the directors. As far as whether it's a data request, you'd have to look at your own policies and procedures and determine whether the requester submitted the data request to a designee or the responsible authority. When an individual submits a data request to the responsible authority or a designee, their rights are triggered under the Data Practices Act.
Okay, we have another question here. With property complaints, is the entire incident report or call for service report confidential, or just the complainant's info, is that their identifying information confidential? And so this is in reference to 13.44 property data, and this is under subdivision 1, where the identities of individuals who register complaints with government entities that concern the violation of state laws or local ordinances concerning the use of real property, those identities are classified as confidential data. And so typically with this, it would just be the identifying information about the complainant. But as just a reminder, identifying information can be more than just someone's name and address. And so if you're looking at the complaint and it has information that would, say something such as, my neighbor's lawn is overgrown and I would like them to, mow it, and that's the complaint, or my neighbor to the west, there might be information in there that could potentially identify the complainant. And so when you get requests for data that deal with property complaints or violations of ordinances for real property, you will want to review it closely just to make sure that all of the information in there is publicly available, and that you redact any sort of complainant or identifying information on the complainant, because that would be confidential. So it's not the entire complaint, it's simply the identifying information about the complainant would be confidential and would need to be redacted. Okay, we've got another question here that says, what steps should an entity take when a data requester doesn't respond to the entity's request for clarification of the request? How long should the entity try to contact, I think, the requester? Is there a process to close the request due to a lack of communication from the requester? I think this is a good question. There isn't a specific process in place to really describe, what to do in a situation where you may need additional clarification. And so this may be something that you would have to think about is, what is reasonable in these sorts of situations in order to fulfill a data request. And so if you reach out to the requester and they haven't responded for 30 days, 40 days, that may be a reasonable time to say, hey, we can no longer fulfill this request because we don't have enough information to do so. But these are sorts of things that you'd want to think about and probably put into your data access policies, just so the public or data subjects are aware of situations when you may close a request because you don't have enough information to actually fulfill it. And so I think that that's kind of up to each government entity. But really, I think keeping in mind what's reasonable, how long to give people to respond to your questions, and when that question, and when there hasn't been a response, when to close that request. I think it's up to entities, but certainly document that in your data request policies.
All right, we still have a few minutes for some questions if anyone else has some questions. Otherwise, thank you for joining us today. Please fill out the poll that is in the polling panel and let us know, provide feedback on what other types of webinars you would like to see on different topics, or what other kinds of questions you'd like to see answered. Otherwise, please feel free to reach out to us in any one of these numbers of ways here on this slide if you have questions about the Data Practices Act and the open meeting law. We had a question about pending legislation. We are going to be doing a webinar on legislative changes. I think we're shooting to do that one in June, so stay tuned. We will also be including all of those changes, any changes that pass, in a newsletter as well this summer. So watch for those things.